Hi everyone, in this week's dispatch video we are on to part 2 of our temporary workers bonanza. In the first video we focused on the day one rights which apply to be provided with access to collective facilities and amenities. Today we're talking about the second day one right which employers may not be aware of, and that is access to employment vacancies. So a common misconception is that there are no real rules or restrictions on when vacancies apply, the process by which an employer has to make a choice as to who to offer employment to. That is a little bit different in the context of the Agency Worker Regulations 2010, because there is a specific right from the start of an assignment for an agency worker to be informed of any relevant vacancies in the hirer during their assignment, in order to be given the same opportunity as a comparable worker to find permanent employment. So the guidance to the Agency Worker Regulation states that the need to inform workers of vacancies is limited to those situations in which there is an actual comparable employee currently based at the same establishment. As we talked about with collective facilities and amenities, I think there will always be a case where there is a permanent employee on site, unless there are only temporary workers or self-employed individuals provided at that location. The hirer may inform the agency worker by general announcement in a suitable place in the hirer's establishment. Liability, as with the failure to provide collective facilities and amenities, sits with the hirer only, so it's not the temporary work agency's responsibility to provide information about those vacancies. The guidance does consider some practical implications. So if there are any particular requirements of an advert, such as qualifications or experience, or even service with as an employee within the business, those opportunities can be restricted such that agency workers do not need to be provided with access to that information. Information on vacancies does not have to be given in the context of a genuine headcount freeze. So where, for example, there is a redundancy situation and there are redeployment opportunities for those people who are at risk, the guidance takes the view that there are not vacancies per se within the organisation that would have to be advertised in those circumstances. And the employer is free to choose how they fulfil their obligations. So if temporary workers don't have access to electronic systems, there's no obligation to create that right simply because other internal candidates might have the opportunity to do so. Ideally, there would be a vacancy list posted somewhere, or perhaps printed information that's provided to that worker. Now, the big restriction on this and the downside for agency workers is that the obligation only goes so far as requiring an employer to inform of any relevant vacancies. The employer is not constrained and has freedom to decide how they treat any applications without any further clarification being provided. Now that does suggest that the agency workers have an equal right to be notified of vacancies, but don't have an equal opportunity to be considered for a role. And case law has made it clear that there is no breach of the regulations where a hirer gives preferential treatment to its permanent staff. A specific case where a long-term agency worker's application for a vacant post was bound to fail, and he was told that that was the case as soon as he expressed an interest. And that perhaps is a gap in the legislation. It creates quite an administrative requirement to inform of vacancies, but then provides no further access to equal treatment. The only other point I would make on this is that it is very common within terms and conditions of business between an employment agency or a temporary work agency and the end user, hirer or business to provide for temp to perm fees. So this is a fee which is payable in the event that the end user wishes to take on the agency worker as a permanent employee. So if they provided access to a particular vacancy and actually selected the agency worker for a particular role, if they want to take them on, there is usually what we call a transfer fee or an extended period of hire that will apply if permanent recruitment follows from that advertisement. So that concludes our two-parter on day one rights under the Agency Worker Regulations. If you do need any more assistance on this topic or indeed anything further, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.